Fine. Today, Ms. Fine will be handling the argument, and I'll be sitting at council table. Thank you, Your Honors.
Thank you. Good morning, Ms. Fine. Please proceed when you're ready.
Thank you, Your Honors, and may it please the court. My name is Allison Fine, and I, alongside my co-counsel, Mr. Robert Wedge and Ms. Hope Garrison, have been appointed as amicus on behalf of the appellant, Ms. Najai. We were asked to address whether the government contacts exception to the DC long-arm statute is limited to First Amendment activities, and this court should find in the affirmative for 3 reasons. First, the text, scope, and history of the DC long-arm statute support this interpretation. Second, since the DC Court of Appeals and Rose versus Silver, that court has repeatedly reaffirmed that the only principled justification for the exception is the First Amendment. And third, the DC Court of Appeals has recognized that other due process or policy concerns associated with the exception can be addressed through other means. The original government contacts exception did have both a due process and a First Amendment justification to it, but that's because it was derived from the DC Service of Process statute. And the exception at issue here comes from the DC long-arm statute. And in Environmental Research versus Lockwood Green Engineers, the DC Court of Appeals recognized that the long-arm statute there was still a government contacts exception under the long-arm statute because that statute was designed to be similar in scope to those of Maryland or Virginia, whose states' long-arm statutes can reach to the fullest extent that due process allows, meaning that the DC statute can also reach to the farthest extent that due process allows. And in footnote 11 of Lockwood, the court also noted that in enacting the long-arm statute, Congress did not mean to eliminate the government contacts exception because doing so would impermissibly burden individuals' ability to exercise their First Amendment rights to petition the government for a redress of grievances. But it wasn't until Rose versus Silver 2 years later that the court had to, quote, come to grips with the question that the Lockwood court didn't have to answer, and that is, what is the justification for the exception? And in Rose, the court said, because the long-arm statute is coextensive with due process, the only remaining justification for the exception is the First Amendment.
So Ms. Fine, assume for the moment that I agree with everything you just said. Why, my question is whether we nevertheless should be certifying this question to the DC Court of Appeals, because that court, in its most recent statement on this issue, said that this exact question is genuinely uncertain. We've sent conflicting messages, and this is the Browder case, which, as you know, then doesn't resolve it. Wouldn't it be a bit odd for us to now say the DC law is clear?
Yes, Your Honor, certification, given the history on this issue, might be proper, but it is not necessary here because although the Court of Appeals might have identified that there is some confusion, especially among the lower courts, about how this applies, the DC Court of Appeals has been very consistent in how it applies. We can look at Rose, which was then followed by Lex Tex, where the court said that in Rose, it had in essence said the First Amendment is the only justification. And then in Campania versus Applied Industrial Materials, in a certified question from this court, the DC Court of Appeals said that Rose and Lex Tex had narrowed the scope of the exception. It cited Rose and Lex Tex in that case. And then Campania carved out an exception to the government contacts principle based on fraud because fraud is not protected under the First Amendment. So doing so wouldn't undermine the First Amendment principles of the exception. And the court...
Our court has sent it, not this exact issue, but our court has sent this complex of issues back to the DC courts a few times because we've also said that the scope of the contacts exception is unclear after the lineage of cases that you described. So has something happened in the interim since we did that would cause us to do something differently now?
The reason you don't need to certify is that when you look at the totality of the case law and how it has built on each other repeatedly over the years, with Lockwood identifying that the exception couldn't be eliminated under the long-arm statute because it would impede individuals' First Amendment rights, with Rose finding that the exception is rooted in First Amendment, with Lex text reiterating that, with Compania then finding the same. And even in the Browder case, Your Honor cited that the policy concerns associated with the exceptions, such as maybe the DC becoming a national judicial forum, we don't need to be concerned about that, because first, due process is a constitutional requirement. We don't need the exception to do that work. It's required in every case, not to mention the long-arm statute reaches that scope. And then policies that exist already, like forum nonconvenience or transfer, can resolve that. So when you look at all of those cases together, Your Honor, that really answers the question. It shows that the justification to the exception, though there might have been language in prior cases that indicates, of course, there was uncertainty in how lower courts were applying it, that the overall principle has been very consistently applied throughout the years.
So the primary question we've been talking about is whether this exception is just for First Amendment activities. Do you think it's clear that the university's contacts with DOE here are not First Amendment activities?
Yes, Your Honor. You could look to the case Beachford versus the trustees of the University of Columbia, where the DC Court of Appeals said that in that case, the only business that Columbia was transacting in the district was soliciting federal grants or obtaining federal loans. And that was precisely what was happening here. Ms. Najai's underlying claims are central to the contact happening in the district, and every harm that she has alleged, the nexus is the district. The universities are obtaining federal loans from the district that they are then handing out to students to further their business as a for-profit institution. Ms. Najai has alleged that the universities have fraudulently taken out loans in her name and then certified her to the Department of Education for collections through the Treasury Offset Program on those loans. So all of those central contacts are happening through DC, and that Beachford case identifies that that falls under the transacting business aspect of the long-arm statute, and that would not be First Amendment activity, because in Lex Text footnote 9, the court noted that First Amendment activities were at a minimum petitioning for a redress of grievances. And
if we were to ask what allegations satisfy the relatedness aspect of the due process inquiry, I assume your answer would basically be the same list of things you just said.
yes, Your Honor.
Okay.
And if I may reserve the remainder of my time for rebuttal, unless you have remaining questions.
I have one question, and
Yes.
we will give you time for rebuttal. So do you understand there to be any dispute among the parties on whether the activities that are relevant are First Amendment activities?
I would expect that opposing counsel may argue that this is First Amendment activities, Your Honor, because there are some district court opinions that might suggest that. However, that Beachford case that I mentioned says the opposite and is a DC Court of Appeals decision.
But do you understand there to be any dispute in the briefing before us on the issue? That
Yes, Your Honor.
you do? You think there is? I didn't see it, but we can ask the other side about that. But I was just wondering about your impression of it.
Are you asking if there's dispute whether among the parties whether this is First Amendment activity?
Yeah, with respect to in the way that it's been presented to us for purposes.
No, sorry, Your Honor.
Okay. All right. Thank you. We'll give you some time for. Let me make sure my colleagues don't have additional.
Oh,
questions
sorry.
for you this time. Okay. Thank you, Ms.
Thank
Hunt. We'll
you.
give you some time for rebuttal. Thank you. Ms. Hare, please proceed when you're ready.
Yes, sir.
Good morning, Your Honors. May it please the court, my name is Deborah Messier, and I represent the defendant appellees, New York University and Long Island University. Your Honors, you've asked for briefing on the question of whether the government contacts exception applies to personal jurisdiction under existing District of Columbia law, and whether it's limited to activities protected by the First Amendment. And the answer, Your Honors, respectfully, is clearly no. Under the district's controlling precedent of Lockwood. Lockwood was en banc, and under DC law, a panel decision cannot a panel cannot issue an opinion that conflicts with en banc decisions. And here I'm thinking of the case MAP, which was cited to by esteemed counsel in the amicus brief. And I'm thinking of the opinion by Justice Gallagher in which he talked about why in Rose they did not take up the case en banc. Your Honors, if I may respectfully offer a clarification of the language in our brief, we apologize. We confusingly refer to Lockwood as the controlling precedent of this court, when of course it is the controlling precedent of the District of Columbia's Court of Appeals. We should have been more precise in our language. Turning back to the argument, Lockwood is premised on the sound public policy that there is a need for unfettered access to federal departments and agencies by our national citizenry, without the chilling effect of having to defend themselves in court in the District of Columbia. The District of Columbia is a very unique, if you will, it has a unique character. Before the 1970s, there was municipal codes relating to the District of Columbia's court system that were then amended. Lockwood is important. It was issued in 1976 to prevent the district from becoming a national judicial forum with jurisdiction over non-residents whose contact with the district was merely interacting with federal agencies and federal instrumentalities. Your Honors, respectfully, in this case, for example, millions of Americans have student loans, old student loans, and are we now to say that those individuals could come into DC, into the District of Columbia, and litigate whether or not they were properly paid or not? Not only would it clog the system, it offends basic principles of minimum contacts that our court system is built upon.
But regardless
So
of
is your view then that where this court has expressed concern about the reach of the exception, the government contacts exception, either the factual or procedural circumstances have been so distinguishable from both the DC Court of Appeals in-bank decision and what it was dealing with there, and this case?
Your Honor, thank you for the question. We do not feel that this case, the case at bar, is distinguishable in terms of the principles of jurisdiction from the Lockwood case. And really, we believe that the DC Court of Appeals should be the ones to, if you will, change their their views on how extensive their jurisdiction should be. And they've been en banc. They've had the opportunity to revise it with Rose and the other cases cited to by amicus, and they've not taken up the opportunity. In the Rose case, Justice Gallagher on the DC Court of Appeals said clearly—
Actually, he's only a judge.
Oh, Judge, I'm sorry, Judge. Judge Gallagher said that he said that it would be, he said that it's very clear that a hearing panel cannot overturn or cabin, to use the phrase of amicus, an en banc decision of the DC Court of Appeals. He made that very, very clear. And he said that was the reason why he didn't feel the need to have rehearing en banc on Rose. And then, of course, he had decisions by other judges who said that we think it probably should be rehearing because this decision may seem to conflict with Lockwood. And they again reiterated the very sound public policy objectives of Lockwood.
Can I ask
Sir.
for Rose, if we thought that Rose cabined the scope of the exception to First Amendment activity, just assume that. I know you would resist it, but just assume that for present purposes.
Yes, sir.
Then I didn't see anywhere in your brief where you argued that the contact exception would still apply because the activity at issue here is First Amendment activity.
Your
Am I right
Honor,
about that?
Your Honor, if we got to that point, I think we would argue that. From our perspective, we were at such an initial phase in this case, at a motion to dismiss before Judge Friedrich in the district court. There's been no fact development here. The facts are to be determined, if you will. We're right at that initial phase of jurisdiction. To respectfully for us, when we looked at Lockwood, it was so clear that there's no question that that the jurisdiction doesn't fall here. But certainly, if you thought that, we would respectfully request the ability to brief that in supplement to, if you would allow that.
Mhm. And what's wrong with certifying?
Certifying to the District of Columbia Court of Appeals. Certainly that is an avenue, Your Honor. I don't think I don't think that there is such confusion that it should be certified. I think that Judge Gallagher and the other judges in the Rose decision made it extremely clear that Lockwood still controls. And I think that if there was a decision perhaps by a court that came out right and said Lockwood is bad, the reasoning behind it is bad, and directly challenged it, then there might be something there. But as the DC Court of Appeals has said, a panel decision simply can't go there. They've had the opportunity,
So what
respectfully, Your Honor.
about, do you have a response to the Lex Tex case? Because my read of that was that it explicitly applies this exception as limited to First Amendment activities. And it applies it in that fashion.
Yes, Your Honor. I understand the language of Lex Tex and some of the other cases cited too by amicus. Again, I have to go back, and I don't want to be too repetitive. I have to go back to that Rose decision with the denial of rehearing. And they said explicitly, it's the law of our District of Columbia court that a panel cannot overturn or modify or change a decision of a rehearing of a court sitting en banc. And the solution to that is to go back en banc. I don't know how it would work if this court were to say the District of Columbia should sit en banc on it. I think that's probably for them to decide, but.
Well, what my question was trying to get at is, given the long-standing view of the DC Court of Appeals and its opportunities, is there something about this case that might cause that court to decide to sit in bank, either ab initio or after a further statement by a 3-judge panel? And the DC Court of Appeals doesn't sit in bank that often, at least historically. And so what is it about this case that gets over the hump? And of course, judges change, and maybe that court would leap at the opportunity to reconsider. But the arguments that are presented here, at least so far, leave me some doubt. And now that you raised the point about the factual development here has yet to occur, what do you think would happen were the matter to get to the DC Court of Appeals, regardless of whether it went to a 3-judge panel or an ab initio in bank proceeding?
Your Honor, of course, any decision by this court would be entitled to great deference and respect by the DC Court of Appeals, I would think.
Now, what I'm trying to focus on, and I'm maybe not clear, is who's going to develop the facts? In other words, is there something about this case, absent factual development, that would make it a good subject for referral? But if I'm on the DC Court of Appeals and I get this case and I have no facts that have been found, And certainly on a motion to dismiss at this point, I can take allegations as true. But that's a lot of work for that court to do, where it's dealing with allegations only. I'm
Yes.
just raising questions. I'm not suggesting where I come out, but there are concerns that I had in considering some of the arguments.
Yes, Your Honor. Your Honors, may I be able to respond? I think my
Yes.
time has expired.
You can respond.
Your Honor, I agree. There has been, the facts as we know it in this case that are undisputed are that again, there's been no fact development. The plaintiff appellant alleges that she attended college in the state of New York, in the village of Brookhaven and Manhattan, in the period of time from, I believe, 1986 to 1989. Presumably, she was a resident of the state of New York at that time. When the plaintiff appellant filed this suit, she was a resident of Pennsylvania. I believe now she may be a resident of Maryland. The way the student loan program works is that there's a program, it is administered by a federal agency that happens to have a portion of its workforce situated in the District of Columbia, but the Department of Education doesn't itself give out federal dollars. It simply administers a program, and the dollars are given out by third-party private lenders. They are given out according to terms agreed to and developed by the Department of Education pursuant to various federal statutes. Those monies are then given out by these third-party banks, if you will, and they are then given to the students to attend the colleges. What I see in this case is the Department of Education, they're out of the case. The two universities are here. There's simply not the minimum contacts here. Respectfully, the plaintiff went to school in New York. Schools are in New York. It's quite unfair to ask entities that do nothing more than accept dollars from a third-party bank operating within the parameters of a federal loan program to then defend themselves in court in the District of Columbia. And the universities are not the ones who actually hired the credit agencies to go after, for lack of a better word, the plaintiff appellant. That would have been done through the Department of Education. So my clients are kind of put in that position, which I believe you would find a lot of entities of, they have a very distant and touching relationship with the district because of the use of that federal program. And now all of a sudden they have to defend themselves in the District of Columbia. And it's not just student loans, respectfully, Your Honors. It would be, think of all the different federal programs. We have Social Security, we have Medicare, we have Medicaid dollars are sent to the states, but they come from the federal government. That just touches on some of the ways that people, entities and people who have nothing to do with the district could be drawn in. I don't know if the District of Columbia wants to clog its courts. I think this would be a case, even if the facts were developed, where the District of Columbia probably would reaffirm their holding in Lockwood and say, this is certainly not a case where we want to think about opening up our jurisdiction. Respectfully, Your Honors, if I may have 1 minute to conclude, unless there are other questions from the panel.
Let me make sure there's no further questions. You can give a brief concluding statement.
Oh, thank you very much. Your Honors, I've touched on a few of these things. I just wanted to talk a little bit about Amicus's contention that a large docket in the District of Columbia or a clogged docket that might result from an expansion of jurisdiction could be dealt with through transfer or forms nonconvenience. Respectfully, jurisdiction is mandatory. That gets rid of the case right off the bat. Form nonconvenience can require a hearing. It's permissive. And it would require people being brought into the district to hire counsel in the district. I'm actually arguing this case on behalf of my firm because I'm the only one admitted in the District of Columbia, in your court, in the DC Circuit Court of Appeals. And so you would have to hire counsel here. It's extraordinarily expensive and time consuming. And
I think we've got the relationship between MEFIN's form nonconvenience and jurisdiction.
yes,
Let me make sure my colleagues don't have additional questions for you at this time. And if there's not, we'll
Thank
take your
you.
argument under submission. We appreciate it.
thank you very much, Your Honors. Thank you for allowing us to present our arguments. And if I may be allowed to also congratulate the law students who've done an amazing job. Thank you.
Thank you, counsel. Ms. Fine, we'll give you the 3 minutes you asked for rebuttal.
Thank you, Your Honors. Your Honors, the DC Court of Appeals has recognized that these policy concerns have already been handled by the exception because due process requires that in order, and under the long-arm statute, in order to bring a claim in the district, it still has to arise from transacting business in the district. So Appley's argument that this would subject basically every university or anyone accepting federal funds of any type to bringing claims in DC or to suit in DC is misplaced because those arguments or those claims still have to arise from transacting business. It can't just be that you received federal money and that was it. Here, Ms. Najai's claims directly relate to the business that the universities are transacting in the business. Her underlying claims directly pertain to the district. It's not like some of the district court cases such as Stevens or Morgan's that Appley cite in their brief where the actual underlying claims occurred outside of the district. Additionally, Lockwood and Rose are not inconsistent with one another. Both cases can still stand true today. They addressed different questions. In Lockwood, the DC Court of Appeals identified that the government contacts exception still exists under the long-arm statute. In Rose, the court said it had to, quote, come to grips with the question Lockwood didn't have to address, meaning what is the justification for the exception. Additionally, the Lockwood case the jurisdiction there was improper because it violated due process. And the only two contacts in DC in that case were direct First Amendment government contacts in the district. So we can't look at Lockwood as saying it said the exception was based on due process, or it said the exception was based on the First Amendment, or even both, because that court was limited to looking at the facts that it had before it. And the facts it had before it was that there were direct First Amendment government contacts. Additionally, the denial of rehearing en banc really cuts in favor of the position that the two cases aren't inconsistent, Your Honors, because as noted in the concurring opinion, the cases, if they were inconsistent, the judges would have to rehear them. And the Rose court specifically stated in the first paragraph of its opinion, Rose and Lockwood are materially different cases, so they don't conflict with one another, which was also reiterated in that decision. And lastly, just on the note of the First Amendment scope here, the First Amendment protections associated with DC are at a minimum, as the court in Lex Text noted in footnote 9, to allow individuals to petition the government for a redress of grievances. It indicated that maybe that's broader, but that's really all that the government contacts exception exists to allow individuals to do. And for these reasons, we respectfully ask that this court find that the government contacts exception is grounded in First Amendment principles. Thank you.
Thank you, Ms. Fine. Thank you to both of you. We'll take this case under submission. Ms. Fine, you and your team are appointed by the court to support the appellant in this matter. We thank you for your able assistance.
Case number 23-1040, Big Rivers Electric Corporation petitioner versus Federal Energy Regulatory Commission. Ms. Raphael for the petitioner, Mr. Shaner for the respondents, Mr. Pearson for the intervener.
Morning, council. Ms. Raphael, please proceed when you're ready.
Thank you. May it please the court, Dana Raphael for petitioner Big Rivers Electric Corporation. For Henderson to join the regional transmission organization and share in its revenues, it had to show that it is an owner of transmission facilities. That requires two things. One, that Henderson is an owner because it owns or controls the facilities. And two, under FERC's 7-factor test, those facilities are transmission, not local distribution. The city of Henderson is a tiny utility serving just 12,000 people, embedded entirely in Big River's transmission system. Because Henderson has no internal generation or connections with any other utility, every electron of power entering Henderson's system comes from Big Rivers. But FERC nevertheless concluded that Henderson was a transmission owner, shifting more than $1 million a year from Big Rivers to Henderson for conveying electricity to itself through and from the Big River system.
So I'd like to be clear about one thing. When the matter was before the administrative law judge, in his opinion, did he not reference the fact that both parties, that is your client as well as Henderson, had experts who examined the documentation that was submitted by Henderson to substantiate its claim of the merits of its petition, and in that respect that it owned the facilities?
Yes, Your Honor. At J390.
So your client had an expert who examined all of Henderson's proffers to the commission.
Yes, Your Honor. Our expert looked at the ownership and control of 6 tie lines, and as to those specific 6 tie lines, argued that Big Rivers actually owned one of those tie lines. And everyone agrees now on appeal that Big Rivers actually did own that tie line all along, the sub 4.
Doesn't everyone also agree that that's not one of the tie lines that's relied on here?
No, Your Honor, that is not agreed to. That is in fact a disputed issue of fact.
And where did your client raise that on in its petition for rehearing? I know it raised it, but I thought part of the argument that the agency was making was that particular tie line wasn't one that was being relied on here by the parties for the purposes of Henderson's petition. Am I wrong about that?
Respectfully, Your Honor, the FERC on appeal has said that that is not one of the tie lines that was relied on, that was not FERC's position before in the proceedings below. FERC said repeatedly, both its trial staff as well as the ALJ, the initial order and the rehearing order, that the sub 4 tap 69 line that everyone agrees Big Rivers now owns was in fact not only one of the disputed facilities, but also that Henderson owned that facility. Henderson itself claimed that it owned that facility in its briefing before the commission.
So how do you read the harmless error principle under the APA?
Your Honor, harmless error has to be applied consistent with Chenery Corps, which is that the agency cannot rely on post hoc explanations. And so when you have a factual error, that is a particularly difficult circumstance for an agency to demonstrate that that error was in fact harmless, because factual errors, particularly those going to the agency's analysis, are very difficult for this court to assess whether that error pervaded the agency's analysis. And our brief cites several cases as to that point. Braniff Airways.
So here, what you would be asking for then is for this court to grant your petition, at least in part, and send it back to FERC to say whether this particular line is part of the operational change that Henderson is seeking, and that at least the agency had heretofore approved.
Well, Your Honor, we'd ask that this court grant the petition in full, vacate the decisions, and remand, because it's not clear whether this error as to the ownership of this tie line pervaded the 7-factor test analysis, which is the second issue on which.
But I'm getting at, hypothetically, take this, that there are 6 lines that are involved in Henderson's petition. And in the course of the proceedings, it turns out only 5 are at issue, in the sense that your client claims that Henderson doesn't own them and Henderson doesn't control them, even though MISO, the client has turned over operational control to MISO, and Henderson would qualify to use those facilities for operations. Would and the point now is that as to the 6th line, in my hypothetical, Henderson doesn't own it, but Henderson's not relying on it for the purposes of its petition. Even in that circumstance, then we would be obligated to send it back to the commission.
Yes, Your Honor, because the 7-factor test is a facility by facility test. That's not the way that FERC actually applied it here. FERC looked at all of the facilities together, including the sub 4 tap 69 line that everyone agrees Big Rivers actually owned all along. And because that mistake pervaded the agency's analysis, it's very difficult to figure out whether the analysis would come out any differently if you change one of those inputs. And there are 2 really concrete examples of this in FERC's brief. FERC at page 32 says that MISO, in fact, studied the flows along sub 4 tap 69 when applying the 7-factor test. And it also, at page 48, says the reason it should prevail on factor 3 under the 7-factor test, it cites a number about 22% of the hours flowing out of Henderson. That number, Your Honors, if you look at JA 88 through 89, that number was MISO's expert, and MISO's expert said that it was relying primarily on this line that is both.
It seems like all of this confusion has arisen because your client turned off this line after these proceedings started. And so both the initial decision and the commission are very clear that they're looking at both pre-reconfiguration and post-reconfiguration. So I guess my specific question to you is, what in the analysis of the post-reconfiguration setup is impacted in any way by the 6th line? Because to me, it seems to come down to this chart on JA 99, which acknowledges that sub 4 tap 69 is turned off. And I didn't see anything in the analysis of post-reconfiguration system that mentions that line at all. So what would you point to dissuade me of that?
Yes, Your Honor. Well, so factor 3 is the only factor in which the commission specifically referenced the post-configuration and did that analysis separately. The rest of the factors do not separate out pre-configuration and post-configuration. And so while the agency said it did not matter whether or not this line was part of the analysis, it didn't then separate its analysis as to each factor. So there's that initial problem. But even as to this 3rd factor, which is when the commission looks at this chart, the commission does two things, Your Honor. So first, pre-configuration, it cites this 22% hours number. And then it says post-configuration, it cites the same expert, this JA99, which comes from this expert Hecker, and says that while there was an increase on one of these lines, and we think that is sufficient based on what the expert said. But if you look at what the expert actually said, she is comparing the increase on that line compared to what the number was before the system configuration.
Right.
So it's still a relational comparison. But if that line that Big River's owned all along, regardless of the disconnection or not, if that line should never have been part of the analysis, then whether there is an increase in relation to the when you look at the numbers with that line in the analysis, then the whole analysis might come out differently. Looking at that number in isolation is very different than doing a comparison when you have an input that shouldn't have been there in the first place. And this is not in the records, Your Honor, but
Well,
been a
don't
lot
give us anything that's not in the record, please. That's part of the problem here.
well, the numbers are in the record, but
No, I'm quite serious about this, counsel. This whole case and your argument is turning on the record.
yes, Your Honor. I misspoke. The table in the record that the parties are referring to and that FERC at 48 is pointing to this 22% of outward flow number. They don't provide the number if you take out this disputed tie line that Big River's actually owned all along. Everyone agrees that Big River's owned, but applying the same math that they applied to get their 22% number, the number would be 2.3%. And so FERC at minimum needs to go back and look at its analysis and determine, okay, Big River's owned this line.
So I did the same math and had the same question, but one thing about this case is, that gets to, so under factor 3 is 8.9% on one line or 2.3% across all lines. Is that more than rare? And I don't think you've challenged that finding on appeal. Your argument seems to be very different, that you should look only to net power flows. And so the time, basically this chart is irrelevant. We should be looking at the magnitude of power going in each direction. And that's sort of in a different bucket than an argument that 2.3 or 8.9 is insufficient.
Well, no, Your Honor. Our position is that the commission applied an overly rigid interpretation of the 7-factor test, and that repeatedly discounted arguments about net power, which isn't just what is the bottom line number, but looking at the amount of power flowing out. River's witness at JA 233 through 234 looked at the charts that Henderson and MISO put into the record, and that even looking at their numbers, 99.7% of the power entering Henderson's system is consumed by Henderson. And the remaining power that is exiting the system, again, when we take out this line that Big River's owned all along and should not have been part of the analysis, when you look at the power exiting the system, that is for these rare contingency scenarios. And the commission's precedent has said when the power exiting the system is relatively small and it's for these border communities or contingency systems, that is not the facility's primary function. And that departure from commission precedent is what Big Rivers is challenging here.
Is your the commission at least says that Hecker's tables are not, they're both under ordinary conditions and emergency conditions. So when this read line shows 8.9%, I think they're saying that's under ordinary operation. Is that incorrect? It sounds like you're saying.
That's not our understanding of the record, Your Honor. Our understanding is that when particularly the ALJ was referring to both normal and contingency operations, those normal operations were referring to when you include the disputed tie line, the tie line that Big Rivers owned, that had normal flows outward. But when you look at just the facilities under the current system configuration, and taking out the one that Big Rivers owns, the outward flow there, Big Rivers has always maintained, is for contingency scenarios. And that is borne out at JA 99 through 100, in which Hecker is talking about this 8.9% and talks about analyzing that number under various contingency scenarios. And Big River's testimony at JA 233 through 234 says that the outward flow is for emergency contingency scenarios. So there really is not a dispute as to that issue. To the extent that the commission wants to take another look at this with the right inputs, that's for the commission in the first instance.
I know you cite Big River's evidence, but what I'm trying to get you to focus on is there was other evidence before the commission. And I mean, Judge Garcia has highlighted why we're in this difficult position, namely because of the sua sponde action of your client, which has been referred. But there was other evidence, and the commission in its orders responds to what it understands the arguments to be. And then on rehearing, with this one exception that you're arguing, it repeats its objections, but points to no evidence, to no error, says the commission. It doesn't tell us where we've erred. So that's why in this one instance, it's important that we hear, and I suppose the agency give us the other sites, not only what your client said, but what the experts said based on their response to your client's evidence, and where both the ALJ and then ultimately the commission came out. And I'm not saying you may not prevail in the end, but it's important, particularly in the circumstances where all of this work was done, and then your client changed the ballgame and now wants to say that it gets the benefit of that. And we want to be very careful. And I thought that's what the ALJ was very careful, because he said, I'm not going to make certain findings because of these changes. But I've looked, as Judge Garcia pointed out, both at the evidence before and after your client's action. And then the commission said the same thing. And that's why, at least one reason I'm asking you so closely about these things, because this is very troubling.
A few responses to that, Your Honor. As to the disconnection, Big Rivers has always maintained that the disconnection was done to enhance the reliability
I
of
understand it has. All right, but the commission has referred that for consideration and not taken any position yet. And I'm not suggesting the court is going to take a position. But your client did not say on rehearing in its petition that it had a legal right to do what it did in the middle of the proceeding, the way it did it. So I'm just dealing with the record we have, and obviously you're going to be much more familiar with Big River's record, and that's why it's helpful to hear what you're citing, so that at least we can hear the argument, how the agency responds, and then decide after you have rebuttal.
Yes, Your Honor. Would you like me to provide the record citations in which the FERC proceedings addressed the ownership question?
Oh, I've already got those in my notes.
Okay. Well, Your Honor, just as to your question on why Big Rivers didn't discuss on rehearing that on this ownership question, Big Rivers did raise its ownership objections. It didn't raise an issue about this system disconnection issue because that was not part of the commission's findings. The commission was very, very clear at JA 453 that the system reconfiguration was not going to factor into, or the reason for the disconnection was not part of the commission's analysis. And so Big Rivers had no reason to object. There was nothing to object to on that front.
To object to its disconnection without authority?
Well, Your Honor, there was nothing to object to because the commission said that it didn't matter.
You understand what I'm getting at, don't you? Wouldn't be in your client's interest to object, but the point is the commission on rehearing was very clear, saying your client repeats the same arguments, but it doesn't show where error has occurred. And the one exception is what we've been talking about mostly this morning. So it's important, at least to me, to understand that that is the circumstance in which the court is considering this case. Because your client and you as a representative know what your burden is in terms of when you seek rehearing by the agency.
Do you mean the decision on the 7-factor test, Your Honor?
I mean the decision in order 580-A.
Yes, Your Honor. So on rehearing, the court did, or FERC did two things. FERC said first, it was going to look back at these ownership and control claims, and the commission said, gave a one sentence, which was that nothing in the record indicates Henderson does not own its facilities, and yet concluded.
Actually, counsel, I was shocked when I went to read that statement in paragraph 11, because that takes that statement out of context and ignores the statements in that same paragraph where the commission specifically refers to Henderson having proved ownership. So that doesn't get you anywhere, at least with this judge.
Well, so Your Honor, the ultimate conclusion on ownership was that Henderson properly owns, operates, or controls the Henderson facilities, which, quote, include the 6 tie lines that are at issue in this docket, including the sub-4 tap 69 line, quote, alleged to be owned by Big Rivers. So the commission concluded, based on apparently the evidence that Henderson submitted, that Henderson owned everything. FERC agrees in its brief, FERC 30, that Big Rivers offered concrete evidence of ownership as to this one disputed line that everyone agrees Big Rivers now owns. And on rehearing, the commission's explanation for how it got to its ownership conclusion was the one sentence, which is that nothing in the record indicates Henderson does not own its facilities. And so Big Rivers' argument before this court is that conclusory sentence on ownership is just not reflective of what FERC did, whether it held Henderson to its burden of proof, whether it looked at what Big Rivers submitted.
Can I ask you one other question? The commission's position based on what was before it, Henderson either had to own or control. And the commission made findings on why it concluded Henderson controlled. And as I understand your argument, this one line still creates a problem.
So yes, Your Honor, we believe that the admitted error as to this one line is the easiest way for this court to cut through this case and to say with an admitted factual error, the easiest thing.
The easiest way, counsel, that's the only way presented. All right, as I see it at this point in terms of what your petition for rehearing raised, how you responded to the commission and what the commission said. And that's what I'm trying to be very clear about in terms of what is before this court at this point. And I mean, I'm going to ask counsel for the agency a lot of questions too, but I mean, I just want to be clear where you are.
Yes, Your Honor. Clear. Is there a particular point that I could clarify?
Well, I mean, I think general statements about the easiest way for us to handle this case, I get that, but I mean, I haven't seen another way. And that's why I brought up this control, because it's ownership or control. And the commission was very careful to separate those two.
Yes, Your Honor, I'm happy to address the control issues as well. We do think that this factual error as to ownership is sufficient because it pervades the entire analysis to send the case back. But separately, as to control, Big Rivers did identify as to these 6 tie lines several contractual agreements that it argued.
And the commission indicated why none of those survived your client's surrender of operational control of its facilities to MISO.
Your Honor, FERC gave 2 reasons why it said that it was not going to consider the substance of these agreements as to the control issue. Both of those reasons do not survive the commission's own precedent and past decision-making.
And it distinguished its precedent.
Well, Your Honor, but the 2 reasons that the commission gave are inconsistent with its own precedent. So FERC, the 2 reasons were FERC said, 1, the agreements were not explicitly listed in the MISO tariff, and 2, that any MISO member can use the facilities. Neither of those reasons are compatible with the Midwest cases that FERC decided previously.
And distinguished. That's my only point, counsel. You may not agree with FERC, but at least the commission in its order and on rehearing distinguished. All right, I'm sorry to take so much time.
My colleagues don't have additional questions.
One
Yeah, of course.
clarification. So we were trying to get to the bottom of whether the inclusion of this 6th line as being owned by Henderson infected any of the other analysis. And I think the specific point you directed me to was the commission saying there was an increase after the disconnect. So there was still a comparison going on. And so even if, just want to understand, even if Henderson doesn't own that line, what was being measured before was still the amount of power flowing from Henderson's lines out across something Big Rivers owns, right? So wouldn't that still be relevant evidence of whether Henderson is transmitting power?
Well, Big River's position before the commission was that because this line was both disconnected and Big Rivers owned it, it should not be part of the analysis, and that the commission had to look at the current system configuration.
Right. So, but if it was just that Big Rivers owned it and we were looking pre the disconnection, it could still be relevant, right? In other words, it wouldn't be wrong to look at what was happening on that line before and after the disconnection, because it's evidence of what Henderson's system is doing, right?
Well, again, Big River's position was that before the commission, that the commission has to look, and its precedent says this very clearly, at the current system configuration, not how the system was historically configured. And because that tie line is not connected, the proper analysis is the current system configuration, not historic flows on a disconnected line.
Thank you.
Okay, why don't we hear from the commission now? We'll give you a little time for rebuttal.
Thank you. And if it's okay with your honors, I may actually raise my podium here on this, and I'm going to put myself on mute briefly while I do that, if that's acceptable.
Sure.
Thank you, your honors. May it please the court, Houston Shaner for respondent, Federal Energy Regulatory Commission. And I'd like to start where Judge Garcia left off quickly to clarify some of the confusion around this. As I understand Big River's argument on rehearing, they never made a claim that all pre-disconnection flows were relevant. They conceded that they were sort of both relevant and never disturbed the commission's findings of paragraphs 22 and 23 of the order on initial decision to that effect. Now, if you look at that in JA page 89, you'll see thousands or really hundreds of thousands of hours of flows both ways, even over the owned tie line, as Judge Garcia noted, which is substantial evidence and evidence that they never really managed to assail below. Now, I also would like to correct the record from some of the previous discussion on table 2 at JA 99 and JA 100. There was some back and forth, including with Judge Rogers, on the normal flows versus contingency scenarios and what this evidence means at JA 99. If you look at JA 99, it is clear it is 3 months of data. In table 2, it is thousands of hours of flows across the lines post disconnection. So that's very clear that it's not merely contingency scenario evidence. The contingencies are described at the top of JA 100. On the next side, you'll see 4 contingency outages listed there, but that is not the same as the evidence on table 2 and JA 99. So I just want to make sure that we're clear at the record there. And this evidence of table 2 is particularly important because, as Judge Garcia discussed earlier, when we're wondering whether or not the sub 4 TAP 69 error, in terms of describing it as one of the proposed facilities, matters for the 7-factor tests, it's very clear it does not here, because Big Rivers actually disconnected the lines. And as the commission found, based on this evidence, the flows largely shifted to other areas. So you still have material flows going between to and from Henderson and Big Rivers during this 3-month period after the disconnection, which sustains the commission's findings in part under factor 3, which is paragraph 78 of the order affirming the initial decision, which I'll call the affirming order here. And that finding is then incorporated as part of the basis for both factors 4 and factors 5. So unlike my friend's assertion earlier, it is not the case that the commission only considered post-disconnection scenarios or evidence for factor 3. It's really factors 3, 4, and 5. The finding of bidirectional flows is most explicit and most fully explained in factor 3 at paragraph 78. But then you'll see the reference to those flows also in paragraphs 87 through 89 for factor 4. Then I believe it's paragraph 96 of the affirming order for factor 5. Now, my friend also mentioned the 99% number, or something to that effect, as I believe for description of the pre-disconnection flows. And we really need to sort of unpack some of the confusion around this. You'll see that 99% number explained at JA 178. This comes from her Big River's expert witness, Chambliss. That number is for the 2015 to 2018 pre-disconnection scenario. And it is a version or a species of what Chambliss calls net flow. But the 99% number he derives is simply by looking at the inflows only and excluding the outflows over the sub 4 TAP 69 tie line, which is both sort of material. It's wrong for one reason, because he's looking at the megawatts, and that's covered in our brief. And I believe Judge Garcia mentioned this earlier. But it's wrong for a second reason, because it's sort of a cherry picking the wrong counterfactual here, cherry picking the data improperly. What in fact happened when they disconnected the flows, as shown again in table 2, many of the outward flows shift. So bidirectional flows were sustained even post-system reconfiguration or disconnection of that line. Now, this is relevant also to the harmless error issue, because my friend sort of raises doubts about whether or not the reference in paragraph 7 of the hearing order to the sub 4 TAP 69 tie line really matters for the 7-factor test. I believe the commission's comparison, or the MISO experts comparison, the commission's adoption of that evidence, showing that both pre and post disconnection, the flows still remain bidirectional, shows you that there is no doubt that factors 3, 4, and 5 here did not depend on ownership of that line. It's just very clear, it's in the record. In that sense, Big Rivers ended up undermining their own argument here, because we know what the world looks like in both situations. The only evidence they have otherwise is sort of this 99% number, which is not a true hypothetical and is simply cherry picking the data.
Well, let me just be clear. I didn't understand your brief to be taking the point that this disconnection didn't make any difference whatsoever. All right, which is.
No, it certainly.
Go ahead.
That's correct. That's correct, Your Honor. Pre-disconnection, if you look at table 1 at J89, you'll see at the sub 4 TAP 69 line, there are nearly continuous outflows from Henderson to Big Rivers. What other witnesses call an almost daily basis of outflows, even though there are also inflows occurring in maybe other points. And if you look at the average of all 6 tie lines, that's the 22% number. That's sort of the hours as a whole. That's the bottom of the chart at J89. But if you're looking really at whether or not there are outward flows, they are nearly continuous there. And it is true that once they disconnect the line, you then go to J99, and that's the table 2. And it's certainly not every day, or not 98.9% of time having outward flows, but it is close to something like 10% It's 8.9% over one line plus some change on the other lines, which gets you rounding up to roughly 10% of the time. And as Judge Garcia said, or noted, the commission was well within its rights under cases like Green Development LLC to say that, look, 10% is enough for factor 3 here to point towards transmission. And because we've established bidirectional flows here, that also informs the commission's analysis under factors 4 and 5. It would separately be, the commission would be within its rights interpreting its own order 888, which, as you've noted, uses the word rarely. And is 10% necessarily insufficient for rarely? There's nothing that establishes that. And certainly nothing that's been preserved jurisdictionally here that establishes that 10% is too low for factor 3. Hopefully I believe that answered your question.
Well, I don't pretend to be an expert in this area, but I mean, a large transmitter resists competition from a small operation. All these years, I haven't seen a disconnect after the petition is filed and the expert evidence.
That is true.
Been
That's why the
examined.
commission called it
That's
unique.
very unusual, and but I never thought that we could just sort of ignore that in terms of the ultimate analysis here. I mean, you heard counsel for Big Rivers this morning say, you know, we don't know what the commission would have done, et cetera, et cetera. And your argument is, yes, we do, because either the flows shifted or as to the flows, they were sufficient under commission precedent. And I'm putting words in your mouth now, but I want to be clear that this is a correct interpretation, that it doesn't matter for purposes of the review of the commission's orders that outflows might have occurred in one spot, but with the disconnect, now they occur in another spot, and the same with the inflows. But that really doesn't matter. And I get the point about you can be a transmitter without all these facilities being close together, but I guess I'm a little unclear, counsel, and help me here, is that are you arguing that if we can find a chart that has the numbers that are adequate under what the commission requires and what statute requires, it really doesn't matter whether the commission was looking at other data and that the experts who were examining the data were looking at other data, because we have a redundancy of data, as it were, that establishes what Henderson had to establish here.
I think the last part of your statement, Judge Rogers, is correct. There is a redundancy of data here. We have it both pre-disconnection and post-disconnection. There's also even a redundancy of experts. The commission, for example, in paragraph 78, reviews the testimony of the MISO witness, Mrs. Hecker, the trial staff witness, Mr. Magna, and then also considers Mr. Chambliss's arguments, even though he's not an engineer, and concludes that the most compelling evidence is the sort of empirical metered evidence of actual flows at JA 99 and 89, along with the contingency scenarios at JA 89 and JA 100.
So you think if I go back and parse the commission's decisions carefully again, that's going to be what I find?
I think you will find it's very clear that the
Counsel's
commission.
argument, which is logical, that expert evidence is only as good as the evidence it's looking at.
To some degree, but the commission understood the evidence here, both at the expert level and the underlying sort of data, and it thought it was quite clear and certainly sufficient to establish that flows outward were more than rare, as the language of factor 3 would require.
I didn't see it use the word redundant, though, in any event. That's my
Oh,
word, not
certainly,
a commission.
But the
word.
commission was, as Judge Rogers noted, very clear that it examined the empirical evidence both before the disconnection and after the disconnection. That's at paragraphs 22 and 23. And then you'll see it again in paragraph 78, and paragraph 78 is the basis for other discussions of bidirectional flows in paragraphs 87 through 89 and then 96.
Counsel, can I ask you to clarify something for me? And I want to be clear. I think this is not really at issue, but it seems that everyone's agreeing that it would be sufficient if Henderson either owns or controls the facilities. Can you help me understand why that makes sense? So hypothetically, if Henderson owned these facilities, but actually had binding contracts that deprived them of control, why would they be able to join a regional transmission system?
That's simply the language of the transmission to owners agreement and also the tariff, I believe, as the tariff defines transmission owner. As the commission notes, the eligibility criteria are phrased as separately sufficient. Both documents use the disjunctive or. I believe you'll see that repeated at rehearing order paragraph 11, as well as affirming order paragraph 4.
Do you have any understanding of why that makes sense if you own but have no control over your own facilities? Maybe the question.
Yeah, I think you are certainly correct, Judge Garcia, in that, especially really with control, what you're looking at here is, can you allow transmission service over these facilities?
Right.
And that's really like the jumping point of this. And that's how you certainly read their control arguments for sure. I mean, the ownership, I think, is sort of straight up and down, and you know, it's just sort of clear in the text, but control is a little bit looser of a concept here. And to start on control there, I would note that Big River's position sort of raises two possibilities, but they can't really meet either of them. On the one hand, they have sort of these, what they call sort of a group of contracts. If those contracts impact or restrict transmission service to or from MISO and the MISO integrated network, then they have to be grandfathered under the MISO tariff, or they're going to be preempted as conflicting with the tariff. Now, there's no dispute here that none of their contracts were actually grandfathered, or they would be listed in attachment P to the MISO tariff, but no one disputes that. So if they make a claim that these contracts in fact restrict transmission service between Henderson and MISO, which includes Big River transmission facilities, then they have to show that those contracts are grandfathered. Now, they wholly failed on that. The other alternative is that the contracts do not in fact affect transmission service. But if they do not affect transmission service, to go to your earlier question, they're not relevant to the legal question of control, because Henderson can still order transmission service. I'm sorry, MISO can still affect transmission service over the Henderson facilities and the Big River facilities. And they try to read the MISO 04 to 05 decisions as creating a sort of liminal space between total irrelevance to control and preemption under the tariff. But that decision simply doesn't say that. The MISO 04 decision says that, okay, you had a grandfathered an agreement that we thought might affect transmission service. You're saying now it doesn't affect transmission service. It only addresses things like financial obligations, which are just sort of orthogonal transmission service. And because of that, we can remove it from the grandfathering list. But if they're correct that these contracts are like those in GFA number 374 in MISO, then they're simply irrelevant to the prospect of control. And that's what the commission was trying to say in paragraph 12 of the rehearing order. And they say that even the commission says that to the extent that these contracts do resemble GA number 374, it does not change the outcome, because you're just not speaking to the question of control. And that is, I think, the easiest out on this sort of eligibility criteria, because there's no dispute that Big River's is signed up to the tariff and the preemption would apply. But there's really no basis for getting out of either that or the question of irrelevance. And really on the relevance issue, they never explain what the contracts do in terms of transmission service. They're not even in the JA. So we're just talking about sort of an amorphous blob of contracts here that supposedly block off service to all 6 tie lines, even though the presiding judge and then the commission at paragraph 32 of the affirming order said that we can dispose of these individually as either not grandfathered or simply irrelevant.
Okay, council, let me make sure my colleagues don't have additional questions for you. Thank you. We'll hear from interveners council now. Mr. Pearson.
Good morning, Your Honors. May it please the court, my name is Steve Pearson on behalf of Intervenor, City of Henderson, Kentucky Utility Commission, Henderson Municipal Power and Light. I'd like to address some of the issues that you've been talking about this morning. I think the biggest issue is the Henderson ownership of facilities. And I'd like to start by pointing the court to Joint Appendix 108 to 110. That is an excerpt of the Transmission Owners Agreement. That is the agreement that Henderson signed with the system operator that initially started this case. Now, what's significant about what's listed at 108 to 110 of the Joint Appendix in that Transmission Owners Agreement is those are the facilities at issue in this case. That is the definitive list. Importantly, one of the facilities that is not on that list is the sub 4 tap 69 line that we've been talking about. It's regrettable that there has been some confusion about ownership that has been created, but that definitive list does not include that tie line. So why are we talking about that tie line pre-disconnection? I think counsel for the commission makes very clear that there was substantial flows over that tie line. So what happened is pre-disconnection, you have a transmission facility, a Big Rivers transmission facility, interconnected with a Henderson transmission facility, substation 4, and you had substantial flows off of the Henderson transmission facility to the Big Rivers transmission facility, indicating that these facilities operate in transmission. As counsel for the commission has pointed out, post-disconnection, you still have substantial transmission flows, or at least sufficient transmission flows that the commission found that it exceeds the rarely if ever test. It's consigned to a different market, consigned to a different geographic area. That's test 4 and 5. And both of those, in both of those findings, the commission references those data tables. And I would also point, council addressed the issue of whether the confusion of ownership of that line infected the entire analysis. Well, I would direct the court to exactly what the 7-factor analysis is. The first one is proximity to load. How could a Big Rivers facility, whether it, it's a Big Rivers facility, so it's not proximate to Henderson's load. It's a Big Rivers facility in factor 2, so it doesn't affect whether the Henderson facilities are looped or radial. We've discussed factors 3, 4, and 5. Factor 6 is metering. There's metering on other facilities, and it's got to be bidirectional, and the record shows that it's bidirectional. And factor 7 really wasn't in dispute in this case. It's voltage. And my time is up, and I would be happy to answer any questions from your honors.
Thank you, counsel. We appreciate your argument.
Thank you, Your Honor.
Raphael, we'll give you 3 minutes for rebuttal.
Few responses, Your Honor. First, it is disputed as to whether the sub 4 line is one of the facilities. If FERC calls that an inadvertent mistake in its briefing, but if it was inadvertent, it was apparently universal. Everyone below treated that facility as one of the disputed facilities.
Could I
Henderson-
ask you, do you agree or do you dispute interveners' direction of the court to the listing of the facilities that are at issue here, namely in the agreement that your client signed? part of which appears at JO 108-110.
Big Rivers did not sign that agreement. That was a submission by the transmission operator, MISO and Henderson. And yes, our client does dispute whether that is necessarily the full list of facilities, because Henderson itself told the commission at JA 441 that it owned the sub 4 tap 69 line. The ALJ acknowledged Big River's ownership claim
So
to
let's
that
be
line.
clear, counsel. When Henderson and MISO signed this agreement saying, here's what we want to do, do you agree that this line that we've been talking about was not listed?
We don't dispute that on the particular JA pages that my friend on the other side points you to, that that line is not on that list.
All right,
However,
so at least as to the party petitioning here in terms of petitioning to the agency for this authority and MISO, those were the only lines at issue. It's not that your client didn't raise objections for all kinds of reasons, but at least the proposal that was on the table.
well,
That's what's so bizarre about this case.
yes, Your Honor, we agree that the situation is a little bizarre, but that's simply not how the commission treated the lines. On the initial order says that Henderson owns and controls that particular tie line. That's J463. Big Rivers objected and said there is evidence in the record, not only that we own this line, but there are control issues as well. And on rehearing, the commission just doubled down and at J515 says
Okay,
there's not.
so counsel, explain to me, if you will, what you think happened here, just so I understand. Henderson went to MISO, they entered an agreement involving, let's just say, 5 lines. By the time the matter got to the hearing, the administrative law judge and his decision, the agreement had morphed into something where Henderson was seeking 6 lines.
It's not clear exactly what happened, Your Honor, but there were
But that is in fact what happened.
Well, Henderson claims that it owned that line and that particular line was at issue. Big Rivers claims.
No, but I'm just trying to understand, counsel, my own mind. Henderson goes and says to me, so I want to be in control of these 5 lines. MISO says, okay, so we've got to go to the commission, we've got to get the tariff, all those sorts of things. But by the time the matter comes before hearing, we're really talking about 6 lines?
I mean, that is perhaps one way to read the record, Your Honor, yes. And
Okay, I just, I mean, you're more familiar with this than I. It's just bizarre. All right, so we're spending all our time on something that the parties, at least initially, said they weren't interested in.
well, Your
Parties being Henderson and MISO, sorry.
right, until Henderson changed its position and claimed ownership over that line. To address much of FERC's argument on appeal is trying to make up for the deficiencies of the commission's order and coming up with new explanations. And the APA requires those explanations to have been given by the agency in the first instance. There are 2 really
So
clear.
if the ALJ opinion says, here's the record, here's the expert testimony, here's all the evidence that they had before them, and I find it sufficient to show that Henderson has ownership and control. And the commission says, on review sought by your client, we're affirming those findings. As I understand it, it's not that the evidence isn't there, but they didn't say something, and it wasn't until the petition for rehearing that the commission finally addressed your client's objection about this 169 line.
Well, a few responses to that, Your Honor. The ALJ did not decide ownership or control. The ALJ says at J 268.
No, I know he didn't, but he cited all the evidence and he cited the experts that your client had and that Henderson had.
Yes, Your Honor. So the first time the commission separately addresses ownership and control is on rehearing, and that's where the commission says explicitly that Henderson
Separately addressed. The commission in Order 580 addresses ownership and control.
Yes, Your Honor, but it speaks in more general terms about ownership and control, and then largely
Henderson owns and, operates, controls.
so it goes through the 6 tie lines as to control, but does not say anything as to ownership specifically. And then Big Rivers objected and said there's evidence that Big Rivers both owns and controls these tie lines. And on rehearing, that's when the commission says that Henderson owns and controls all these lines and that nothing in the record indicates otherwise. And so before this court, our argument was that the evidence that Big Rivers put into the record about ownership and control was simply incompatible with the commission's statement that nothing in the record indicated otherwise. Now, the commission believes that on appeal, that perhaps there was this robust burden shifting.
Counsel, I agree with that, but that's not the way your brief reads.
Oh, well, Your Honor, that's exactly what we said in our briefing, which was that
You said that the commission hadn't met its burden of proof because look, it was saying that the burden was not on Henderson to show that it had ownership or control. I mean, with all due respect, counsel, you say that you cite this sentence at least twice in your brief.
Yes, Your Honor. So when we filed our opening brief, the commission still had not admitted that it had apparently agrees now that it made this error. And so what Big Rivers had before it was the evidence put into the record as to ownership and control, the commission's one-line statement that nothing in the record indicated otherwise. And Big Rivers' position was that that one-line statement seemed to put the burden of proof on Big Rivers to disprove ownership and control when the burden of proof was on Henderson and MISO to affirmatively demonstrate ownership and control. Now, the commission's answer on appeal is that apparently the commission engaged in this robust burden shifting analysis and concluded Big Rivers did not meet its burden. But
in the commission's decision, all right, on rehearing, we've talked about paragraph 11, where the commission says we remain unpersuaded, and you say the commission's just wrong about that. All right, and now on appeal, the commission acknowledges it's wrong, at least in the part. But then as to paragraph 12 on rehearing in order 580-A, the commission states, quote, moreover, we sustain the explanation and conclusions in our previous opinion that Big Rivers has turned over operational control of its facilities to MISO, comma, including Big Rivers substation and tie lines that interconnect with the Henderson facilities. MISO's use of the relevant facilities is not limited by Big Rivers cited statements. Big Rivers cited agreements. Big Rivers has not disputed that it gave MISO operational control of its facilities and does not allege that the agreements actually were grandfathered. And it goes on. So as to control, there was a clear finding. Control. Sorry.
Yes, Your Honor. So the argument about the complete lack of explanation, the burden shifting problem, that was as to ownership. But turning to
But it says, moreover, in other words, even if we're wrong about all that, all right, look, Henderson has control. And what it's required to have is either ownership or control.
Yes, Your Honor. But as to control, as Big Rivers argued in its opening brief, there were 2 defects in the commission's answer as to control and defects that the commission has yet to explain on appeal. And in fact, this is a perfect example of the commission coming up with explanations on appeal that differ from what the.
Excuse me, but counsel, those alleged errors are your client disagrees with the commission's interpretation of its precedent.
Respectfully, Your Honor, no, that's not right.
That's what you said. You said the commission gave 2 reasons, right?
Yes, Your Honor, and neither reason is compatible with the decisions that FERC gave before. And FERC
And that's what I'm saying. FERC interpreted its precedent differently than you or your client. That's all I'm getting at. I'm not saying who's right or wrong, but that's what happened.
Well, Your Honor, FERC attempts to come up with explanations on appeal, but those answers differ from what the commission said. So a perfect example of this is that the commission says at 519 that these agreements.
Counsel, I'm focusing on what the commission said. Right?
Yes,
It said it didn't agree with your client's interpretation of its precedent. And it said why? It said those situations were different.
Your Honor, it did not address the 2 reasons that it gave, but that was the first time the commission gave those reasons. And so Big Rivers is arguing here that those 2 reasons are not compatible with the precedent. And an example of this is that the Midwest cases, the commission said at 519 on rehearing that the agreements in those cases were, quote, similar and relevant respects to the agreements in this case. Now, FERC's brief at FERC 38 transforms that finding and says that the agreements were similar in some respects, but ultimately irrelevant. That's not what the commission said on rehearing, which is that they were similar and relevant respects. Now, the 2 reasons.
What paragraph are you citing? So I'm clear.
That's paragraph 12, Your Honor.
That's where
Yes, so it's on 519 at the top on the 3rd line, the 2nd and 3rd line, similar and relevant respects.
Yes. I mean,
Now,
relevant respects doesn't mean necessarily dispositive, does it?
perhaps not, Your Honor, but the finding was similar and relevant respects, and FERC on appeal changes that to some respects, but ultimately irrelevant. That's not what the commission said. Now, again, the 2 reasons that the commission said that these past cases were not pertinent to this case, despite the finding of the similarity between the agreements themselves, was that the agreements were not listed in the tariff. But that was just as true in the Midwest cases, where in Midwest, the entire premise of the commission's process was to determine whether those agreements should be listed in the tariff. An attachment.
In the Midwest, were the agreements part of the record?
I'm not aware if they were.
Well, they're not a part of the record here. You agree with that, don't you?
Well, they're part of the agency record, Your Honor. They're not in the joint appendix because the commission determined that the substance of the agreements, it wasn't even going to look at the substance. So we did not feel that there was any basis to put them in the joint appendix itself, but we're happy.
Even on appeal, they're not in the record for the court to look at, right?
In the joint appendix before this court, Your Honor, but they are in the administrative record. Their Big Rivers Exhibits 5, 6, and 9 submitted those agreements in full. There were certainly factual disputes as to what these agreements said and did, and the commission simply didn't wade into any of that because it gave these 2 reasons that it said it wasn't going to look at them. But again, those reasons have to be compatible with the commission's previous precedent. And when the commission has said in the past that the Midwest cases, that the agreements could be excluded from attachment P, which JA 455 talks about how attachment P is the MISO tariff's official listing of permissible grandfathered agreements. And so agreements could be excluded from the tariff and yet, quote, remain in effect and not be impacted by such lack of inclusion in the tariff. Big Rivers argued the same circumstance should be true here. If the agreements are not listed in the tariff, they should still be operative. So the reason the commission gave was not compatible with its own prior decision. Now, the second reason that the commission gave, which is that MISO had control over these facilities, was a similar problem in that the transmission owner there was also a member of MISO. And so if membership in MISO was sufficient to make those agreements not operative, then surely the commission couldn't have said that the agreements would, quote, not be impacted by such lack of inclusion in the tariff. And the commission still has no answer to those arguments on appeal. The commission instead, its counsel says that the agreements were just irrelevant. That's not what the commission said. Now, there are certainly circumstances in which the commission could parse the record and come out the way that FERC's counsel on appeal says that it could come out, but there's no guarantee of that. And where there's any uncertainty and an admitted factual error, the right answer is to send it back to FERC to look at this in the first instance. Thank you.
So you think the commission's whole discussion of its precedent when it was looking for purposes of opinion number 579 is irrelevant?
Opinion 579, Your Honor?
Yes, that's at the, let's see what page. That's on the rehearing at JA 519. That's where it starts.
You mean paragraph 12 that's discussing the Midwest cases?
No, you've already told me what you think of that. So that's why I asked you about what appears now as to the discussions as to Order 579, which appears starting at paragraph 13 et al.
Grid lines, Your Honor. So that pertains to the 7-factor test. That's not related.
Correct. That's what I'm dealing with now. That's what the subheading says, 7-factor test for jurisdictional transmission facilities. That's what the commission's order says. That's what it's dealing with here.
Yes, Your Honor. So just to clarify, so there are two issues that FERC has to win on here, both ownership and the 7-factor test. And on the 7-factor test, Big River's argument was that the commission's explanations were not consistent with its precedent, and Grid Alliance is part of that the commission.
And the commission answers is all I'm getting at. You may not agree with its answer, but it answers. It says Big Rivers mischaracterizes the commission's analysis and conclusions. I mean, you may disagree with that, but that is what the commission said on rehearing, as opposed to suggesting it just didn't look at it and, never responded to Big River's argument. That's all I'm getting at.
Yes, Your Honor. Big River's position was never that the commission ignored Grid Alliance specifically. Big River's position on the 7-factor test was that the commission departed from its past precedent, which looks at the primary function of a facility and not particular contingency operations. And that Grid Alliance was a great example of this because Grid Alliance talked about net flow and looked at net power flow. And yet the commission on multiple factors said that net flow was not relevant. And so Grid Alliance was part of Big River's larger argument that this departure from precedent was violated the APA.
As to the 7-factor test.
As to the 7-factor test, yes, Your Honor.
Okay, thank you, counsel. Let me make sure my colleagues don't have additional questions for you. If not, we'll thank you. Thanks to all counsel. We'll take this case under submission.
Tuesday, March 5th at 9:30 a.m.